Now we arrive at one of the most consistently live topics in the entire PYQ record. In 2016, 2018, and now 2025, with Jammu and Kashmir's reorganization. If federalism is about how the union and states share power, but union territories are the exception that tests how far the union can concentrate power when there is no full state to share it with. Then you may ask one question: why do union territories exist at all rather than every part of India being a full state? For that, I am saying Article 1 describes India as a union of states, but also lists union territories separately. What are the union territories for that matter? These are regions administered directly by the President of India, typically through an administrator, under Article 239. Historically, these were small territories, border sensitive regions, or areas requiring closer central oversight, like Chandigarh, Andaman and Nicobar Islands, Lakshadweep, where full statehood was either impractical or in border and security sensitive cases deliberately withheld as union territories. Most union territories have no legislature at all, governed entirely by the administrator on the president behalf. So, but two categories break this pattern, and both are exactly where UPSC concentrates its questions, like Delhi and Puducherry. As far as Delhi is concerned, under Article 239 AA and Puducherry under Article 239A. And now, since the 2019 reorganization, Jammu and Kashmir, a new hybrid category, the 2025 PYQ asks about directly. Comes to the Delhi. In the Delhi case, Delhi is the classic case. The 69th constitutional amendment in 1991 gave the National Capital Territory of Delhi its own elected legislative assembly and a council of ministers headed by a chief minister. But notably, this legislature cannot make laws on public order, police, and land, which remain with the union through the lieutenant governor. Public order, police, public order, police, land held by the union through the lieutenant governor. This half state but half union territory structure is precisely designed to balance two competing needs. One is democratic self government for Delhi's residents and central control over a capital city with unique security sensitives. These competing needs has to be balanced. The 2016 PYQs essentially question is exactly this design's fault line. What is that fault line? What happens when the elected government and the LG, Lieutenant Governor, representing the union, disagree over where public order and police ends an ordinary administration begins? What happened in 2016? Here you have to name the cases because this dispute now spans three rounds of litigation and legislation. And the sequence itself is the answer. Comes to the round number one. What is the round number one? Government of NCT of Delhi versus Union of India 2018 case. In this case, the Constitution bench referenced in that year's PYQ held that the LG is bound by the aid and advice of the Delhi Council of Ministers on matters within the Assembly's competence. Has no independent decision making power except in the specifically excluded areas, and that any matter the LG may refer to the president does not mean every matter. Except public order, land and police, LG have to be must aid and advise of the Delhi Council of Ministers. Except these three. And one more thing, that any matter LG may refer to the president does not mean every matter. That is the round one in 2018. Round two, 2023 Constitution Bench judgment in the services dispute held that the elected Delhi government controls administrative services, the bureaucracy outside the three excluded subjects. On the principle that an elected government without control over its own officers is accountability without power. In the round two, the issue is bureaucracy. Then comes to the round three. Within days, the union responded with an ordinance, later enacted as the GNCTD Amendment Act 2023, creating the National Capital Civil Service Authority with the chief minister outnumbered by two central appointees and restoring decisive central influence over services. The act's constitutionality it is itself under challenge before the Supreme Court. Judgment, legislation overriding, judgment, fresh challenge. Notice this is structurally the same parliament versus court pattern we just saw with the Tribunals Reform Act. And pointing out that parallel in an answer is exactly the kind of cross topic synthesis GSE rewards. In the round one, we have seen LG versus GNCTD versus Union of India Constitutional Bench, then LG bound by aid and advice on matters within the assembly competence. LG may refer to the president. It is not the meaning of every matter you have to LG has to refer to the president. And comes to the 2023 service judgment, constitutional bench. Elected government controls the bureaucracy outside the three excluded subjects. What are the subjects? Public order, police, and land. A government without control its officers is accountability without power. That is the constitutional bench said. Comes to the 2023 ordinance. Center gave ordinance to GNCTD Amendment Act 2023 and created National Capital Civil Services Authority, and CM outnumbered by two central appointees. Central influence restored. Constitutionality itself under SC challenge. So here judgment, then legislation overriding it, then fresh challenge. Structurally identical to the Tribunals Reforms Act story. This where cross-topic synthesis is GS2 rewards as far as UPSC CSE GS2 mains is concerned. And comes to the Jammu and Kashmir. What is the Jammu and Kashmir? Now Jammu and Kashmir, the 2025 PYQs focus. The Jammu and Kashmir Reorganization Act 2019, following the reading down of Article 370's special status, converted the former state into two union territories, that is Jammu and Kashmir with its own legislative assembly and Ladakh without legislative assembly. So Jammu and Kashmir's assembly resembles Delhi's model in spirit, like an elected legislature operating under a union territory framework rather than full statehood, but with its own specific list of subjects and its own timeline toward eventual restoration of statehood. The Supreme Court's December 2023 verdict upholding the abrogation of Article 370 also recorded the Union's assurance that statehood would be restored at the earliest. And assembly elections were duly held in 2024, but statehood itself remains pending, which makes this a topic you must actively track right up to the exam. Any movement, any movement on statehood restoration instantly becomes the current affairs book for this question. So the PYQ, what the PYQ asked, the PYQ specifically asked the nature of assembly and its powers and functions. Wants you to place this squarely within the Delhi Puducherry pattern of UT with a legislature. While noting the security and constitutional history context that makes Jammu and Kashmir's case distinct from the Delhi's purely administrative capital rationale. This is regarding about Jammu and Kashmir Reorganization Act and abrogation of 370 article and federal spectrum. Comes to the answer writing part. Suppose UPSC asks a question like this. Compare the constitutional design of union territories with the legislatures and evaluate whether this model adequately balances central oversight with democratic self-government. This is the question. I will repeat question again. Compare the constitutional design of union territories with the legislatures and evaluate whether this model adequately balances central oversight with democratic self-government. Comes to the answer structure. First and foremost, what you have to do is explain explain the general union territory framework under Article 239, then contrast the hybrid Delhi and Puducherry models under 239 AA and 239A, situates J&K's 2019 reorganization within this pattern. And next one, you have to discuss as the Delhi LG jurisdiction dispute through the named 2018 and 2023 judgment. And then the GNCTD Amendment Act sequence and closes by evaluating whether such partial self-government structurally invites recurring center versus elected government friction, or whether it is a reasonable compromise for security sensitive or historically unique territories. So let us, this is the way of answer writing. First you have to do explain the general UT framework under Article 239, then contrast the hybrid Delhi and Puducherry models under Article 239AA and 239A respectively, then situates J&K's 2019 reorganization within this pattern, within this pattern, and then discuss the Delhi LG jurisdiction disputes through the named 2018 and 2023 judgments and the GNCTD Amendment Act sequence. And closes by, you have to closes by evaluating whether such partial self-government structurally invites recurring center versus elected government friction, or whether it is a reasonable compromise for security sensitive or historically unique territories. This is the way of the answer writing. So let us summarize. Union territories, especially the ones with legislatures, are federalism's unresolved corner. Why? Neither fully centralized like an ordinary UT or ordinary union territory, nor fully autonomous like a state. And that deliberate incompleteness is exactly what they keep generating fresh constitutional disputes. So comes to the quick recap before we moving on. The fully centralized, the federal structure spectrum is like this: fully centralized. This is the ordinary union territories. These are having no legislature. Administrative Administrator answers only to the president. This is the fully centralized. These are the UTs directly ruled by administrator and through president. And comes to the next one, that is hybrid. Hybrid means union territories with legislature, that is Puducherry 239A under article, then Delhi 239AA, and Jammu and Kashmir 2019 act. That is, these are police, public order and land are held back with center, that is union. Except these three these three list from union. Then comes to the fully autonomous ordinary states, full state list powers within the general center state balance. So this is the federal spectrum. Comes to the one line rule, that is you have to carry forward. The closer a territory sits to the center on this spectrum, the more its accountability chain runs through the president and lieutenant governor rather than the ballot box. And the trade off is deliberate, not accidental. The more accountability runs through president and LG rather than the ballot box. A deliberate trade off is this. This is all about union territories, Jammu and Kashmir till now. And it comes to the important thing, that is center and Ladakh. This is the paradox. The sixth schedule versus Article 371 question. And before we leave the union territory spectrum, we must stop at its most centralized point, because that is exactly where the most live center territory dispute in the country is unfolding right now. That is center and Ladakh. No PYQ has asked this directly yet, and that is precisely the point. This is the highest probability fresh question in this entire chapter for 2026, because it combines a UT question and a tribal protection question, union territory question, as well as a tribal protection question and an asymmetric federalism question into the one ongoing negotiation. This is consisting with three dimensions, that is UT question, tribal protection question, and asymmetric federalism question. So start with the paradox. The 2019 reorganization gave Jammu and Kashmir a union territory with a legislature. Comes to the Ladakh part. Ladakh became a union territory without legislature, governed entirely by the lieutenant governor. For Leh, which had long demanded union territory status separate from Srinagar's dominance, in 2019 initially looked like a victory. Looked like a victory. Within 2 years, that celebration turned into agitation. Why? Why? Because Ladakhis realized that under the old arrangement, they had at least two protections. What are the protections? The restrictions on outsiders acquiring land, which flowed from Article 35A. This is the first protection, and itself issued under Article 370's authority. and an elected state government they could vote in or out. Elected state government. So the new arrangement removed both at once. The restrictions on outsiders acquiring land, which flowed from Article 35A, itself issued under Article 370C, 370's authority, and an elected state government they could vote in or out. The new arrangement removed both at once. No legislature, no special land protection, direct central administration. A region, a region that is roughly 97% scheduled tribe found itself with less formal protection for its land, jobs, and culture than it had before. And less than what the sixth schedule gives far smaller tribal populations in the northeast. Less than what the sixth schedule gives far smaller tribal population in the northeast. Hence, the demands articulated jointly by two bodies whose unity is itself politically remarkable. That is, the lay apex body representing the Buddhist majority lay and the Kargil Democratic Alliance representing Muslim majority Kargil. These two communities, with a long history of divergent politics, now negotiating as one. Lay apex body and Kargil Democratic Alliance, historically divergent, both are, but now negotiating as one. What are the four demands? Their 4 point agenda. What are the 4 point agenda? Four demands, that is full statehood and inclusion of Ladakh in the sixth schedule and a dedicated Ladakh Public Service Commission with employment safeguards and two separate Lok Sabha seats for Leh and Kargil. The National Commission for Scheduled Tribes itself recommended sixth schedule status for Ladakh back in 2019. So the demand is not merely political, it carries the endorsement of a constitutional body by National Commission for Scheduled Tribes. The sixth schedule creates autonomous district councils with real legislative, judicial, and financial powers over land, forests, and customary matters. And it currently applies only to Assam, Meghalaya, Tripura, and Mizoram. The center dilemma here. Now the center's dilemma, and this is where the analysis lives. What is the dilemma? The sixth schedule creates what? Autonomous district councils with real legislative, judicial, and financial powers over land, forest, and customary matters. And it currently applies only to Assam, Meghalaya, Tripura, and Mizoram. So, extending it to Ladakh would be the first extension outside the Northeast. And the center fears two things in this context. What are the two things? A precedent effect. Gorkhaland and other tribal region demands would immediately invoke the Ladakh example. And one more thing, the security concern, because Ladakh borders with both China and Pakistan, and the Union is reluctant to layer autonomous land control institutions over a theater of active military deployment. These are the center's two fears. One is precedent, and the second one is security. So the center's counter offer has consistently been a different instrument from the same toolkit. Not the sixth schedule, but Article 371 style special provisions, which recall from the scene coming next. That is, protect land, culture, and customary law in states like Nagaland and Mizoram without creating autonomous councils. One instrument, the sixth schedule, devolves institutional power. The other, the Article 371, entrenches protection while keeping the governance structure intact. That distinction, power versus protection, it is the single sharpest analytical line you can draw in any answer as far as Ladakh is concerned. So the escalation timeline matters because UPSC increasingly asks process, not just structure. Sustained protests and repeated hunger strikes by climate activist Sonam Wangchuk kept the issue alive through 2023 and 2024. Then interim concessions came through Article 240 regulations in 2025. Reservation for locals raised to 85%, a 15-year domicile rule, and one-third women's representation in the hill councils, five new districts. This is the interim concession. Interim concessions came through Article 240 regulations in 2025. What are they? Reservation for locals, 85% local reservation, 15-year domicile, and 1 by 3 women in hill councils, and 5 new districts. Then September 2025, protests in late turned violent. At least 4 protesters were killed and nearly 100 injured. And Wangchuk was detained under the National Security Act. At detention, the MHA, Ministry of Home Affairs, itself revoked in March 2026, explicitly to rebuild trust ahead of Supreme Court hearing. Notice what the sequence demonstrates here. Preventive detention deployed against a civil society movement, then walked back under judicial and political pressure. A governance and rights dimension that lets you use Ladakh governance and rights dimension that lets you use Ladakh in GS2 questions well beyond federalism. So, and now the breakthrough, which makes this is most current topic in your entire preparation as far as union territories is concerned. Through 2026, the high powered committee under the Ministry of Home Affairs and its subcommittee have moved from stalemate to agreed minutes. What are the agreed minutes? As of the meeting concludes in mid 2026, the two sides have agreed in principle on a UT level elected body with executive, financial, and legislative powers. Statehood explicitly retained as the long term aspiration, but deferred with the center indicating openness to safeguards drawn from anywhere in the Article 371A to 371J family if they give Ladakh stronger protection. And agreeing that the bureaucracy's performance appraisals would ultimately rest with elected executive once it created. And seriously considering dedicated Ladakh administrative services and Ladakh police service cadres alongside the demanded public service commission. If this framework is enacted, what watch what it means constitutionally. Ladakh would move along our federal spectrum from its most centralized point toward the Delhi Puducherry hybrid zone, a fourth UT with the legislature, but with a bespoken design negotiated rather than imposed. You have to track the formal legal instrument that eventually delivers this. And a constitutional amendment creating a new 239 series or 371 series provisions are a parliament statute, because the choice of instrument is itself the answer to how entrenched is the protection. Comes to the Ladakh we are discussing so far, instruments, escalations, and, and breakthrough. Sixth schedule devolves legislature and institutional power elected autonomous district councils. Then Article 371 entrenches protections, keeps governance intact, the center's counter offer. So comes to the center, it has two fears, president and security. Comes to the answer writing part, the demand for sixth schedule status for Ladakh highlights the tension between tribal autonomy, democratic governance, and national security in India's border regions. Discuss. This is the question. Answer like this. You have to write. Opens with the 2019 reorganization paradox. Protections lost alongside statehood. Presents the four demands and the NCST's 2019 recommendation. Contrast the sixth schedule's power devolving design with Article 371's protection, entrenching design as the two competing instruments, then present the center's precedent and security concerns fairly, brings in the 2025 violence and NSA detention as the cost of delayed accommodation, cites the 2026 in principle agreement on an elected UT body as the emerging middle path, and concludes with this chapter's own recurring insight, that is negotiated asymmetric accommodation, not imposed uniformity, is how the Indian constitution has historically resolved exactly this kind of dispute, from Nagaland's 16-point agreement to now Ladakh. So Ladakh wants to, simply I am saying, Ladakh wants sixth schedule and statehood, they asked. But center fears two things. Precedent thing. First one is the Gorkha and other tribal regions demands would invoke Ladakh if they give. And comes to the security part, Ladakh borders with China and Pakistan, so no autonomous land control over an active military theater. So this is the two center fears. For that matter, center is arranging 371 competing as the constitutional vehicle, like Nagaland 16-point agreement, and already 2025 Article 240 regulations 85% local reservation, 15-year domicile rule, and 1 by 3 women in hill councils, and 5 new districts. After September 2025 lay violence, then in the March 2026 detention revoked, and then middle 2026 in principle deal. In this elected UT level body with executive, financial, legislative powers, and 371 family safeguards, and statehood deferred, and Ladakh, all in Ladakh administrative services, police services, cadres are considered. So what's the legal instrument that delivers it? Amendment 239 series or 371 series versus statute itself, the answer how entrenched the protection. So Ladakh is the federal spectrum being renegotiated in real time. A territory demanding to move from the spectrum's most centralized end toward elected self-government, with the sixth schedule and Article 371 competing as the constitutional vehicle. Whatever instrument finally carries the settlement, the underlying lesson is one this whole part keeps teaching, where the union under provides democratic accountability and land culture protection, agitation fills the gap until accommodation follows. This is the all things about Ladakh, center Ladakh. I will summarize it again. Ladakh is the federal spectrum being renegotiated in real time. What is the Ladakh series? We have to go into very depth. That is going growing in 2019. What was happened? Jammu and Kashmir reorganization happened. With that, union territory with state legislature, Jammu and Kashmir, then Ladakh without legislature as union territory, directly administered by administrator. So this is happened. And one more thing happened, that is land. What happened? The restrictions on outsider, the two protections before that, the restrictions on outsiders acquiring land, and elected state government they could vote in or out. These new arrangement removed both at once. That is the thing happened. That is the thing happened. So what? So actually 97% of scheduled tribe found itself in this Ladakh region. So what happened? They want to Ladakh put under sixth schedule like Northeast. But center fears two things. Like if accepted this thing, precedented Gorkhaland and other tribal region demands could invoke as Ladakh. And then security thing, that is Ladakh is bordering with China and Pakistan. So no autonomous land control over an active military theater. Because if you give sixth schedule, autonomous land control, they have to make autonomous land council, district councils. So that is why these two fears center have dilemmas. In that context, in finally in mid 2026, center deals with in principle deals with what is the deal? Elected union territory level body with executive, financial and legislative powers, and then 371 family regards, safeguards and statehood deferred, and Ladakh administrative services and police services cadres are considered. This is the discussion as far as Ladakh and the center is concerned. Then we are moving to Article 371 series, that is called as Asymmetric Federalism. What is the 371 family? What is the 371 series? The 371A article, it is belongs to Nagaland. What is that act particularly? What is that article? No act of parliament on Naga religious or social practice, customary law and justice, or land and resources applies unless the assembly so resolves. What is this? This is the short but real gap comes next. And notice how naturally we arrive here. The center's own counteroffer to Ladakh is drawn from exactly this family of provisions. Under Article 371A was tested directly in 2013, and it represents a broader constitutional principle worth understanding even at lower PYQ frequency. Not every state fits the same federal template. We established in federalism that India is often called a union of states with a strong center. But you look closely, and the constitution does not actually treat every state identically. Why? For that matter, Article 371 through 371J carve out special provisions for specific states. So Maharashtra and Gujarat get provisions for state development boards for certain regions like Vidarbha, and Nagaland under Article 371A protects Naga customary law and procedure, and this is exact 2013 PYQ point. Provides that no act of parliament on religious or social practices of the Nagas, Naga customary law, civil and criminal justice administered per Naga customary law, or ownership and transfer of land and its resources applies to Nagaland unless the state assembly decides so by resolution. Without resolution of assembly, no act of parliament on Naga religious, social practices, customary law, and justice or land resources applies. So the state assembly have to resolution make. Comes to the Mizoram, Article 371G has near identical protections. Comes to the Sikkim, Article 371F protects its pre-merger laws and gives its assembly special seat arrangements. Pre-merger laws. And Andhra Pradesh and Telangana, Article 371D deal with equitable opportunities in education and public employment across the state's different regions. So, why does this matter constitutionally beyond memorizing which article covers which state? Why? Why does it matters? Why? Federalism is asymmetric, calibrated to history, culture, and integration terms. That is why Nagaland and Mizoram's provisions exist, because their integration into union came with specific promises about protecting tribal customary law and land rights. Comes to the Nagaland, Nagaland's 371A traces directly to the 16-point agreement of 1960 between the Naga People's Convention and the Government of India. So, a detail that anchor the provision in negotiated integration rather than unilateral grant. So, it is given deep local resistance to uniform central law overriding indigenous practice. So, asymmetric federalism. So this is precisely the same logic recall behind PESA's Grama Sabha protections in 5th schedule area under the 6th schedule's autonomous district council in the northeast. So this is a genuine constitutional family. Wherever the union anticipated that uniform national law could threaten a distinct local social or land rights order, it built in a protective carve out rather than forcing uniformity, because that nature is different. And note that contrast that completes the analytical picture. 370 was labeled as temporary and read down in 2019, but 371 series carries no such label. That is why permanent and unaffected by abrogation. While the Article 371 series carries no such label, the Union government itself has repeatedly clarified that the 371 provisions are permanent special arrangements not affected by the 370 abrogation. A distinction worth one line in any answer written after 2019. The comes to the 2013 scenario. What is the 2013 PYQ specific scenario? In that, in that case, a Ministry of Petroleum directive perceived as threatening Nagaland special status tests exactly this. What is that? What was that? Whether an ordinary central directive concerning natural resources can override the specific land and the resource protections carved out under 371A. The 371 has real legal teeth, restricting ordinary parliament and executive reach. This is not symbolism. So, in this case, Petroleum Directive versus Nagaland in 2013 scenario. Ministry of Petroleum Directive perceived as threatening Nagaland special status tests exactly this. What was the exactly test? Whether an ordinary central directive concerning natural resource can override the specific land and resource protections carved out under 371A. That is the importance of 371 family. So the analytical point is, as far as UPSC is concerned, UPSC wants is that any central action touching land or resource ownership in Nagaland genuinely does require sensitivity to this constitutional carve out. It is not merely symbolic, it has the real legal teeth restricting ordinary parliament and executive reach. Without resolution of assembly, no act of parliament or executive directive would not apply in Nagaland case as far as this particular case is concerned. Comes to the answer writing part. Discuss how the Article 371 series reflects asymmetric federalism in India with a specific reference to Article 371A. What should be the answer? First and foremost, what you have to do explains why the constitution departs from uniform treatment of states for a specific subset. Then discuss 371A, A's protection for Naga customary law and land ownership as the clearest example with its 16-point agreement origin. Then briefly notes the broader family of special provisions across other states and the 370 versus 371 performance distinction. Then connects this with to the fifth and sixth schedule protections studied under local government and federalism, and concludes with that asymmetric federalism is not a weakness of the constitution but a deliberate accommodation of India's genuine social and historical diversity. This is where most aspirants lost marks by treating Article 371 as a memorization exercise rather than a principle. It is proof that federalism with a strong center is not the whole story here, where deep historical and cultural sensitivities demanded it. The constitution chose accommodation over uniformity, and that choice still shapes real disputes today. We have now mentioned the fifth and sixth schedules three times in this part under PESA, under the 371 family, and throughout the Ladakh scene, without once stopping to actually open them. What is that actually fifth schedule and sixth schedule? Let us fix that now because with Ladakh's sixth schedule, demand dominating headlines. This is quite possibly the highest probability fresh question in this entire chapter for mains 2026. And the 2016 mains question on constitutional provisions for tribal upliftment tells you what UPSC has tested this territory before and will test it again. So we are going to start from the constitutional look. Article 244. Clause 1 applies the fifth schedule to the administration of scheduled areas and scheduled tribes in any state other than Assam, Meghalaya, Tripura, and Mizoram. What clause 2 applies? Clause 2 applies the sixth schedule to tribal areas in exactly those four states. Remember them with mnemonic ATMM. Assam, A for Assam, T for Tripura, M for Meghalaya, and M for Mizoram. Assam, Tripura, Meghalaya, Mizoram. One article, two entirely different philosophies of protection. And that difference is the whole examination point. So comes to the fifth schedule. What is the fifth schedule? Fifth schedule, the protection via the executive. What is the machinery here? President declares schedule areas across 10 states. Andhra Pradesh, Telangana, Jharkhand, Chhattisgarh, Odisha, and Madhya Pradesh. Governor may display or modify any law. Regulations on tribal land transfer, allotment, and money lending. The three historic tools of this dispossession. So comes to this thing, the fifth schedule is a protection model run through the executive. Simple. The president declares schedule areas currently spread across 10 states from Andhra Pradesh and Telangana through Jharkhand, Chhattisgarh, Odisha, Madhya Pradesh, and others. Then after that, what happens? Within them, the governor holds extraordinary powers to direct that any act of parliament or the state legislature shall not apply or apply with modifications. That's it. And to make regulation for peace and good governance, especially to prohibit or restrict the transfer of tribal land to non-tribals, regulate land allotment, and regulate money lending, and three historic instruments of tribal dispossession, etc. etc. President declares schedule areas. Governor may apply or disapply or modify any law. Majorly regulation on tribal land transfer, allotment, and money lending. These three historical dispossession, instruments of tribal dispossession. So each such state has a tribes advisory council up to 20 members. Three-fourths, three-fourths of them scheduled tribe members of the state assembly to advise on tribal welfare. And the governor reports annually to the president with the union's executive power extending to giving directions to the state on scheduled area administration. So tribes here, tribes advisory council, more than 20 members, and 3 by 4th are STMLAs, and the governor reports annually to the president. Union may direct the state. This is the things happening. So comes to this design part. Protection flows downward through the president, then governor, not upward from tribal self-government. So the top-down design is precisely why Parliament had to add PESA. What is the PESA? The Panchayat's extension to Scheduled Areas Act 1996. This is PESA Act, which extended Part 9, Part 9's Panchayat framework to fifth schedule areas, but with a radical twist. What is that radical twist? The Gram Sabha, the village assembly itself, was made the pivot, empowered to safeguard community resources and customary practices, to be consulted before land acquisition, to control minor forest produces, minor minerals, minor water bodies, local markets, and money lending and intoxicants. As far as PESA 1996 Act is concerned, Grama Sabha is the center, that is the pivot. Consulted before land acquisition, controls minor forest produce, minerals, water bodies, markets, and money lending. This is comes under this. So comes to the judicial reinforcement part. In Samatha versus State of Andhra Pradesh 1997, the Supreme Court held that government land in scheduled areas could not be leased to non-tribals for mining. Reading the fifth schedule's land protection expansively. And the honest criticism here is because UPSC will expect it. Tribes advisory councils are frequently dormant. Governors have rarely exercised their discretionary protective powers independently of the Council of Ministers. Several states took decades to frame PESA rules, and land alienation and displacement in scheduled areas have continued through mining and infrastructure projects, regardless the familiar gap between paper protection and ground reality that runs through this entire chapter. So, what is the fifth schedule? Fifth schedule is protection of via the executive. This is the fifth schedule. In this fifth schedule, what happened? First, president declare particular area as scheduled area across the 10 states, that is AP, Telangana, Jharkhand, Chhattisgarh, Odisha, MP, etc. Then after that, what happened? Governor may disapply or modify any law. Then governor what to do? Give a notification regarding regulation on tribal and land transfer, allotment, and money lending. These three. Then what happened? Create a tribes advisory council. In that tribes advisory council, less than 20 members. Less than 20 members are equal to 20 members. That in that 3 by 4th are STMLAs. So governor reports this annually to the president. Then union may direct the state accordingly. This is the process. This is the process starting from president to tribal council, tribes advisory council. This is top down approach. The flow comes from top to down. This is happening. Then comes to the PESA Act. What is this act? In 1996, Part 9. What is the Part 9? Local Government Act. Local government, local self-government, like Panchayati Raj systems. These are extensions, extensions for scheduled areas. Panchayat Extension to Scheduled Areas Act 1996. In this act, what happened? In the scheduled areas also, Gram Sabha is the pivot. Gram Sabha is the pivot. We have to, anybody have to consulted Gram Sabha before land acquisition, and controls minor forest produce and minerals, water bodies, and markets, and money lending. This is given by PESA Act 1996 to Grama Sabha. And then comes to the judicial pronouncement. In Samatha versus Andhra Pradesh case 1997, Supreme Court gave a judgment. That is the beautiful judgment. What is that? Government land in scheduled areas cannot be leased to non-tribals for mining. The beautiful judgment. This is expansively increase the power of scheduled areas for tribal people. And comes to the criticism part. These are things are well and good. But honest criticism is generally dormant. Tribes advisory councils are dormant. Governors rarely act independently. Why? Because they are purely act under guidelines of aid and advice of Council of Ministers. Then decades late, PESA rules applied for that scheduled areas. Then continual land alienation is happened. So that is the paper versus action is in this particular fifth schedule. So structure is designed. Protection flows downward through president and governor, not upward from tribal self-government. So this is the familiar gap between paper protection and ground reality that runs through this entire chapter. This is all regarding about fifth schedule protection via the executive from president, then governor, then tribes advice council. Then we are moving to sixth schedule, that is autonomy via elected councils. In this autonomous district councils, same Ladakh wants this type of sixth schedule protections. In this what? The sixth schedule is the opposite philosophy, an autonomy model run through elected institutions. In this what happened? It creates autonomous district council. In this up to 30 members, up to 30 members, up to 30 members, 26 elected for 5-year terms and 4 nominated by governor. Total autonomous district councils, each district council 30 members. 26 members are elected for 5-year terms and 4 members are nominated by governor. With genuinely three-dimensional powers. What are the three dimensionals? Comes to the legislative power. Laws on land, forests other than reserved forests, shifting cultivation, village administration, inheritance, marriage and divorce, and social customs, subject to the governor assent. These items, legislative items. What are the legislative items? Land, forest, inheritance, marriage, customs, etc. Comes to the judicial part. What are the judicial part? Village councils and courts try disputes between tribals with the council as an appellate layer. Village councils and courts to try disputes disputes between tribals with the council as an appellate layer. Then comes to the financial part. Power to assess and collect land revenue, impose specified taxes, and receive royalties from licenses for mineral extraction. Crucially, acts of parliament and the state legislature either do not apply to these areas or apply with modifications. The same non-application device we saw in Article 371A, but here vested in an elected local body rather than the state assembly. So that is the regarding about autonomous district councils are powerful in this particular sixth schedule states. So comes to the Bodoland Territorial Council in Assam, the largest one, runs an expanded strength under later amendments. And note one structural prelims laws. What is that? The 73rd and 74th amendments do not apply to sixth scheduled areas. These regions have district councils instead of panchayats, a deliberate preservation of the older autonomy design. The sixth schedule has its own honest criticism. What is that criticism? Friction and overlapping jurisdiction with the state governments, dependence on state and central funds, despite formal financial powers, allegations of elite capture within councils, and weak accountability and audit, and the long pending 125th Constitutional Amendment Bill, which proposes what is the 125th Constitutional Amendment Bill, which proposes elected village municipal councils and finance commission style devolution within sixth scheduled areas. Still awaiting that passage. Itself a good one line current affairs mention. That is the thing. So, what is the sixth schedule? Sixth schedule is Autonomous District Council. This is present in Assam, Tripura, Meghalaya, and Mizoram. In this autonomous district councils, 30 members, 30 members are there. In this, 26 members are elected for 5-year term and 4 were nominated by governor. These autonomous district councils, three powers, that is legislative, judicial, and financial. Comes to the legislative part, what? Land, forest, inheritance, marriage, and customs. These are comes under this autonomous district council. Comes to the judicial part, village courts and appellates. Appellates, autonomous district council as appellate layer. And then comes to the financial part, land revenue, taxes, and mineral royalties are collecting autonomous district council. So comes to the central state acts, may not apply or apply modified, like 371A's device vested in an elected local body. But in 371A, it comes to the state assembly reserve, state assembly resolution. But here autonomous district councils only. Then comes to the 73rd and 74th amendment, do not apply here for autonomous district councils. Not apply here. Autonomous district councils are the ultimate power in this sixth schedule. Those are autonomy centric, elected council driven. So comes to the 125th amendment bill also pending in front of parliament. So this is the, in that 125th constitutional amendment bill, which proposes elected village municipal councils and finance commission style devolution within sixth scheduled areas. So after this fifth and sixth schedule, we have to side by side, side by side comparison. What is the comparison? Comes to the fifth schedule. Fifth schedule is protection centric, governor driven, governor and president driven, advisory tribal voice, applies across 10 mainland states, supplemented by PESA's Gram Sabha powers. These are well and good. Comes to the sixth schedule part, autonomy centric. Fifth schedule is protection centric. Sixth schedule is autonomy centric. Fifth schedule is governor driven, president driven. Here the elected councils with real legislative, judicial, financial powers confined to 4 northeastern states, that is Assam, Tripura, Meghalaya, and Mizoram. And now connect it to everything this part has built. What is that? This is exactly the power versus protection distinction we draw in the Ladakh scene. power versus protection. The Ladakh's movement demands the sixth schedule's power model, but the center offers the 371 families and fifth schedule style protection model. The NCST recommended the sixth schedule for Ladakh in 2019 precisely because Ladakh's roughly 97% tribal population exceeds that of most existing sixth scheduled areas, which makes the center's refusal a question of precedent and security, not of eligibility. Ladakh demands for this power model. The center offers protection model, the 371 family, and fifth scheduled style. One more connective thread here for a truly synthetic answer. Article 244A inserted in 1969 even permits the creation of an autonomous state. Within Assam, proof that the constitution's designers built an entire graduated ladder of tribal autonomy. From PESA's village level powers through district councils up to a potential autonomous state with full statehood at the top. Asymmetric federalism, once again, is not an exception to the Indian constitutional design. It is the design. Comes to the Article 244A in 1969, what it says, an autonomous state within Assam, a graduated ladder for ladder of tribal autonomy exists by design. Comes to the answer writing. Suppose UPSC asks, compare the fifth and sixth schedules as instrument of tribal protection and examine whether the demand for extending the sixth schedule beyond the northeast is justified. The answer is like this. Article 244 contrasts the executive protection model with the elected autonomy model using two or three concrete powers from each, then brings in PESA and Samata for fifth schedule, and the 73rd and 74th exclusion for sixth, presents the Ladakh demand with the NCST's 2019 recommendation on one side and the center's precedent and security concerns on the other side, notes the 2026 negotiated middle path of an elected UT body with 371 family safeguards, and concludes that the Constitution's own graduate ladder of tribal autonomy suggests extension is a question of political will and context, not constitutional impossibility. The fifth schedule protects tribals from outside forces through the executive. The sixth schedule empowers tribals to govern themselves through elected councils. Every current dispute in this space, Ladakh, PESA implementation, land alienation in scheduled areas, is ultimately an argument about which of these two philosophies a given region deserves, and that framing alone will carry you through any question UPSC builds on this topic. The fifth schedule protect land alienation. The sixth schedule given autonomy, the simple thing. Then comes to the Lokpal and Lokayuktas. And finally in this chapter, the Lokpal, lower PYQ frequency than the rest, appearing in 2013, but worthy a proper standalone treatment rather than one line mention. It received in part 1. Since it is exactly the kind of institution UPSC tends to revisit once implementation issues accumulate. What is Lokpal? What is Lokayukta? Before the act, cite the intellectual lineage in one line. I am going to. What is that? It is high value and almost nobody uses it. The idea of an Indian ombudsman goes back to the first ARC. What is the lineage and jurisdiction? first ARC in 1966. Then second ARC mentioned in ethics in governance. Then 2013 it came into act, recommended and shelved, half century bills lapsing since 1968. This is the lineage. Then comes to the born of the civil society anti-corruption movement. This is the legislation shaped by pressure groups. It covers PM with few exclusions like international relations, security, and public order. And ministers, MPs, Group A, Group B, Group C, Group D, employees, and Lokayuktas at state level uneven. So this is the lineage, this is the jurisdiction. And it comes to the implementation critic. This is the most important thing because first Lokpal appointed only in 2019. After 2013 Act made, Lokpal appointed in 2019. 6 years. So the 6 years after that Act, look at this. Then selection committee design questioned again. Eminent jurist seat, leader of opposition treatment when no party qualifies. Then investigation wings independence. This is this is this is the important thing you have to understand. You have to remember because investigation wings independence is not there. Low conviction relevant output overlap with CBI and CVC must rely on. So, what is the criticism here? The criticism here is, and precisely the 2013 PYQ's framing. A national Lokpal, however strong, cannot resolve the problems of immorality in public affairs. Finds a limitation. This entire chapter has repeated in different forms. An institution can investigate and recommend, but corruption is ultimately a governance culture problem, not solvable by a single watchdog body alone. Corruption is governance culture problem. The Lokpal itself faced years of delay in actual appointment. After the act was passed, the first Lokpal was appointed only in 2019. That is 6 years after the act. And the criticism has focused on the composition of the selection committee, particularly the eminent jurist seat, and the treatment of the leader of opposition's position when no party qualifies for that status. So the practical independence of its investigation wing, its low conviction, relevant output relative to complaints received. So, and it is jurisdictional overlap with CBI and CVC. It often has to rely on for actual investigation. Comes to the answer writing part. The question is 2013 question is a national Lokpal, however strong it may be, cannot resolve the problems of immorality in public affairs. Discuss. You have to open with the first ARC and second ARC ethics in governance lineage, then explains the Lokpal statutory basis and jurisdiction, then situates it within the broader family of accountability institutions, that is CVC, CAG, CBI, and it must coordinate with, and then evaluates the delay and composition criticisms and argues that institutional anti-corruption machinery is necessary but not sufficient, then requiring complementary reforms in transparency, that is RTI, political funding, and bureaucratic culture. The very ecosystem the second ARC's ethics framework described to meaningfully reduce corruption. This is the way of the writing an answer. So let us summarize this. The Lokpal completes the anti-corruption institutional architecture on paper, but exactly like NHRC's teeth problem and the Information Commission's independence problem, it is the real effectiveness depends on appointment, integrity, resourcing, and coordination with the CBI, not on the Act's text alone. Ground reality is important. Independence is important. Then comes to the Representation of People Act. What is the Representation of People Act? We already discussed the law beneath every election. So one more institution remains, that is, except one is not a body at all. It is a statute, and look at its PYQ record before you decide how much it deserves. In 2025, 2024, 2022, 2020, 2019, 2018, 2017, 7 times, 7 questions in 9 years makes the Representations of People Act the single most repeatedly tested piece of legislation in GS2 paper with its own dedicated syllabus line. And UPSC rotates through the same 4 zones, that is disqualifications, corrupt practices, election disputes, and electoral reforms. This is 1950 and 1951 Act, RPA Act. So master these 4 zones. What are the 4 zones? Disqualifications, corrupt practices, election disputes, and electoral reforms. These are the 4 zones. Master these 4 zones and every RPA question become answerable. Then we are going to start with the constitutional hook. What is the constitutional hook here? Because it is explains why these statutes exist at all. The Article 327 and Article 328 empower Parliament and the state legislature to make laws on all matters relating to elections. And the Parliament used that power twice, in 1950 and 1951. The RPA 1950 handles the machinery before the election, like allocation of seats, delimitation of constituencies, preparation of electoral rolls, and the qualification of voters. Comes under 1950 RPA. And then comes to the RPA 1951. It handles everything from the election onward, like the actual conduct of elections, qualifications and disqualification of candidates and members, and corrupt practices and electoral offences, and the resolution of electoral disputes, resolution of election disputes. 1950 is about the voter and the roll, and 1951 is about the candidate and the contest. This is the two acts, 1950 RPA and 1951 RPA. Comes to the zone 1 we are going to discuss, that is disqualification part. In 2019 and 2020 PYQs asked regarding section 8 of the 1951 Act. What is this? Section 8 of the 1951 Act disqualifies a person convicted of specified offenses, specified offenses, and for most offenses anyone sentenced to imprisonment for 2 years or more. The disqualification running for the period of imprisonment plus 6 years after release. Section 8 of the 1951, it says anyone sentenced to imprisonment of 2 years or more, it will affect them, it will attract them. The disqualification running for the period of imprisonment and plus 6 years after release. So now the case, every answer must cite. What is that case? Lily Thomas versus Union of India 2013. In that case, UPS Supreme Court struck down Section 8 Clause 4. What is that? Which had allowed sitting legislators a 3-month window to appeal and continue in office despite conviction. So after Lily Thomas, conviction means immediate disqualification for sitting members too. The single biggest judicially driven decriminalization step in this space. In Lilly Thomas versus Union of India 2013 case, where the Supreme Court struck down Section 8, Clause 4. What is that section? Which had allowed sitting legislators for a 3-month window to appeal and continue in office despite conviction. Even after conviction, that section allowed sitting legislators for 3-month window to appeal. In 2013 Lilly Thomas versus Union of India case, Supreme Court struck down that section. After Lilly Thomas conviction, after Lilly Thomas case, conviction means immediate disqualification for sitting members too. Immediate disqualification for sitting members also. That is the single biggest judicially driven decriminalization step in this space. And the surrounding sections for completeness. Section 9A disqualifies for subsisting government contracts. Section 10A for failure to lodge the account of election expenses and the detailed examiner's reward. Section 11 empowers the election commission to remove or reduce a disqualification, a discretionary power that has itself drawn scrutiny when exercises. The remedies which the 2019 PYQ asked about by name and appellate courts stay the conviction itself, not merely the sentence, lift the disqualification, and ECI section 11 power remains the statutory safety valve. So 2020 PYQ that the procedure of disqualification for corrupt practices needs simplification, points at multi-stage litigation heavy route from High Court finding to presidential decision on the ECI's opinion, a process so slow it often outlasts the term of the House itself. So comes to the zone 2, that is corrupt practices. The 2025 and 2022 PYQ territory this is. Section 123 lists them: bribery, undue influence, appeals to vote, or refrain from voting on grounds of religion, race, caste, community, or language, promotion of enmity, publication of false statements about a candidate's character, free conveyance of voters, expenditure beyond the prescribed limit, and booth capturing. These are comes under corrupt practices and section 123. The two judgments gives this list its modern meaning. In Abhiram Singh versus CD Komachen 2017, a 7-judge bench reads section 123 clause 3 broadly. What it says: the bar on religious and similar appeals covers appeals in the name of religion or caste of the candidate or of the voters, making identity based vote seeking a corrupt practice in its widest sense. And then comes to the Krishnamurti versus Shivakumar 2015 case, held that non-disclosure or false disclosure of criminal antecedents in the election affidavit amounts to undue influence because it interferes with the voters' free exercise of electoral choices and it is therefore a corrupt practice. Now comes to the 2025 PYQ's precise puzzle. Does a legislator disproportionate increase in asset constitute undue influence? Undue influence. The honest high scoring answer is layered. A mere increase in wealth during a term is not by itself listed anywhere in section 123. But the Krishnamurti logic extends naturally. If the disproportionate assets traced back to a false or suppressed affidavit at the time of the election, the false disclosure itself is the undue influence. vitiating the voters' informed choice. And in Lok Prahari versus Union of India 2018 case, the Supreme Court strengthened exactly this architecture, requiring candidates to disclose their and their associates' source of income and treating unexplained disproportionate assets growth of legislators as a matter of warranting security and warranting scrutiny. So the answer shaped like this, not automatically a corrupt practice, but convertible into the one through the disclosure route. And the deeper reform point is that the disclosure regime built almost entirely by the judiciary from Union of India versus Association of Democratic Reforms 2002 onward has become the voter's primary weapon where the state statutes own list runs out. The, in this section, corrupt practices 123 section and Abhiram Singh versus and Abhiram Singh case and Krishnamurthy versus Shivakumar 2015 case listed out and Association Union of India and Democratic Reforms Association of ADR case 2002 onwards has become the voters' primary weapon where the statutes own list runs out. And then comes to the zone 3, that is election disputes. What are the election disputes? Election disputes, the 2022 PYQ's territory, asked with unusual procedural specificity. Comes to Article 329B, bars courts from interfering with an election except through an election petition. No mid-election judicial intervention. The petition lies only before the High Court, must be filed within 45 days of the result, and the grounds for declaring an election void sit in Section 100. Improper acceptance of a nomination, a corrupt practice committed by the candidate or agent, improper reception or refusal of votes, and non-compliance with the Constitution or Act, with the crucial qualifier that for several grounds the petitioner must show the result was materially affected. Appeal lies to the Supreme Court within 30 days. The design principle worth one analytical line. Elections are deliberately insulated from ordinary litigation during their course and challenged only afterward through this exclusive statutory channel. Certainty of electoral calendar ranked above immediate judicial correction. So comes to the election dispute part, Article 329B bars courts intervention in this election. Only election petition allowed under Section 100. Only direct to go to the High Court after a result of election, 45 days only. Then comes to the appeal part. Within 30 days, you can go to Supreme Court after the High Court verdict. So this is the statutory channel. This is the judicial correction. Comes to the election dispute part. Then comes to the zone 4 electoral reforms. This is most important thing, that is electoral reforms. 2024 and 2017 PYQ's territory this is. The zone that is most current right now, I am saying this is the committee lineage first, because the 2024 question asked for it by name, the Dinesh Goswami Committee 1990 and Comprehensive Electoral Reform, the Indrajit Gupta Committee 1998 on State Funding of Elections, the Law Commission's 178th Report 1999 and 255th Report 2015, the second ARC's Ethics Report, and the ECI's own 2016 compendium of proposed reforms, the 2017 PYQ's direct subject. So then the reform that will dominate 2026 as far as RPA is concerned. So one nation, one election. The sequence to carry. The Kovind High Level Committee's recommendations were accepted by the Cabinet in September 2024. The Constitution 129th Amendment Bill 2024, inserting a new Article 82A for synchronized Lok Sabha and Assembly elections with midterm elections filling only the unexpired remainder of a term, was introduced on 17th December 2024 alongside a UT Laws Amendment Bill. And both were referred to a 39-member Joint Parliamentary Committee, whose tenure has been extended into the 2026 monsoon session. That is meaning the JPC report is due almost exactly when you sit for mains, which is why this is a near certain question. So you have to know both sides with equal fluency. For reduced election cost and administrative strain, the end of near permanent model code of conduct freezes on governance, a common electoral role, and comes to the against, comes to the cons. The federalism objection, state elections subordinated to national calendar and truncated terms for assemblies dissolved mid-cycle. The accountability objection, the 2017 PYQ itself framed fewer elections mean fewer movements the government answers to voters. And the design objection senior jurists have raised before the JPC, including a former Chief Justice criticism that the proposed Article 8 to 82A gives the Election Commission excessive discretion to delink excessive discretion to delink an assembly election from the simultaneous cycle and complete the reform picture with the two adjacent currents. What are they? The electoral bond scheme struck down by Constitution bench in February 2024 as violating voters' right to information under Article 19, Clause 1, Subclause A. That is political funding reform reopened. So that is comes to the electoral reforms. You have to check with this. And the EVM VVPAT question from 2018 PYQ, updated by the Supreme Court's April 2024 judgment, declining 100% VVPAT verification while adding limited post result verifications safeguards. The court's consistent line being that electoral integrity is protected through verifiability and process, not through returning to ballot paper. For answer writing part, take the 2025 PYQ, discuss the corrupt practices for the purpose of Representation of the People Act 1951, analyze whether the increasing the assets of legislators disproportionate to their known sources of income would constitute undue influence and consequently a corrupt practice. First and foremost, list the section 123 heads compactly, then anchors undue influence in inference with free electoral choice, then deploys Krishnamurthy and Abhiram Singh cases for the modern expansive reading, answers the asset question in the layered way, not per se corrupt practices but convertible through false or suppressed disclosure, with Lok Prahari as the brigade. Lok Prahari as the bridge and concludes the judiciary has progressively converted the voters' right to know to the real enforcement mechanism of electoral purity, doing through Article 19, subclass class 1, subclass A, what section 123's closed list could not. So let us summarize and notice how perfectly this statute completes the chapter. Every institution we have studied holds the executive count accountable. The RPA is one of the law holds that elected representatives himself accountable for how he got elected, what he disclosed, and whether he stays qualified to remain. It's four zones: disqualification, corrupt practices, disputes, and reform are all one question in different cloths. How does a democracy police the entry gate of power? And with the one nation, one election report due in the very season you write mains. So no topic in this entire script carries a higher probability of appearing paper rather than one nation, one election. Then comes to the this is all about RPA. The four zones, the repeated question, seven questions, seven times asked regarding RPA 1950 and 1951. The zone 1, 2, 3, 4 reforms, election dispute, disqualification, corrupt practices, etc. So comes to the synthesis part, the three themes behind every question in this chapter. What is the synthesis? Independence, accountability, federal balance. Then comes to independence part, how appointed, for how long, removed how. Comes to the COGS, judge style removal, RTI tenure, executive rules, NHRC shortened tenure from 5 years to 3 years. Then Tribunal Act's tenure struck down in November 2025 under the executive central government rules. And then comes to accountability. What is the accountability? Recommendatory or binding? Mostly recommendatory rather than binding. NCW, NCPCR, NHRC, RTI, Information Commission, Must Anyone Act, NHRC advisory findings, Lokpal's CBI overlap, CAG reports, no legal force, real political weight here. And comes to the federal balance, concentrate or carve out. Comes to the CBI, consent part, Article 131 suit by West Bengal. NIS, no consent design. Comes to Delhi 3 rounds, 2023, 2016. Comes to 2016 Delhi versus the central Delhi versus LG. Delhi elected government versus LG. Then comes to the services part. Then 371 series Asymmetric, 371A Nagaland case. Comes to Mizoram, Andhra Pradesh, Telangana, etc. So comes to this point. Before we close, notice something interesting in this here. Something that should change how you prepare for GS2 from here on. UPSC never actually asks isolated facts about these institutions. Because look back across everything we have covered in this part, and you will find it keeps circling around exactly three themes, dressed in different institution clothing each time. The first theme is independence. How is the office holder appointed? For how long? And how are they removed? Comes to the CAG, 6 year term, and judge style removal. In the RTI amendments, shift of commissioner, tenure from statute to executive rule. In the NHRC shortened post 2019 tenure, and its staffings by officials run from the very ecosystem of policies, and its Tribunal Reforms Act's tenure provisions, and the court's November 2025 response to them. And whenever a question describes a body's appointment process in unusual detail, it is really asking you to judge its independence. The independence lies in appointment, and independence lies in how long office holder, and independence standing in how are they removed. Then comes to the second theme, that is accountability. What is accountability? Recommendatory or binding? Reports to whom? And does anyone have to act on them? The NHRC recommendatory only findings. The Lokpal is overlapped with CBI or CVC, and it cannot fully control. Comes to the CAG's report to the carry, no legal force but real political weight. These are all the same questions in different words. Does these institutions output actually bind anyone? Or does its power depend on someone else choosing to listen? That is the weakness. The third theme is federal balance. How much does the union concentrate power, and how much does it share or carve out? And the CBI's general consent mechanism and the pending Article 131 suit, the NIS deliberate no consent design, and Delhi split control over services through three grounds of judgment legislation and Article 371 series asymmetric protections are all one continuous argument about where the line between union authority or local or state autonomy should sit, and why UPSC keeps moving the specific example while asking the identical structural question. And notice the pattern that now connects two of this part's biggest stories. In both the tribunals dispute and Delhi services dispute, a Supreme Court judgment was followed by a legislation, effectively overriding it, following by a fresh constitutional challenge through ordinance, then constitutional challenge, then legislative overruling versus judicial finality is quietly becoming GS to them in its own right. Carry that phrase because it lets you connect topics most aspirants treat as unrelated. But once you recognize these three themes like accountability, independence, and federal balance, you recognize these three themes, a strange thing happens. What is that strange thing? Institutions you have never specifically revised become easier to answer because you already know which of the three questions the examiner is really asking. What are the three questions? Accountability, independence, federal balance. That is the system based approach this entire part has been building toward, one institution at a time. So every institution in this part shares the same underlying pattern. The pattern behind every institution every institution in this part shares the same underlying pattern this entire revision script has returned to again and again. A specialized body created to solve a specific governance problem whose actual effectiveness depends less on its founding text and more on the independence of its amendment process, the adequacy of its resourcing, and its relationship with the constitutional courts and a parliament above it. A specialized body created to solve a specific governance problem whose actual effectiveness depends less on its founding text and more on the independence of its appointment process, the adequacy of its resourcing, and its relationship with constitutional courts and a parliament above it. This is not a coincidence. It is the single most consistently rewarded analytical frame in GS2 mains answers and is worth carrying into every institutions you study, whether or not it appears in the script. So, what is the track actively until Mains 2026 is National Tribunals Commission, constituted and in what form, and comes to J&K statehood restoration and Ladakh settlement, which legal instrument carries it, and one nation, one election commission, one election. The JPC reported due in monsoon 2026. These are you have to track for 2026 mains. Thank you.